Okay, Mr. Samuels is here. Kelsey Alvarado is here.
Good morning, Your Honor.
Okay, thank you. I just was checking to make sure you were here. I'm not calling that case just yet. On the record, in the matter of the people of the state of Michigan versus Usama Habata, file number 22-01765. Council Pierce.
Good morning, Your Honor. Case Markarian appearing on behalf of the people. I'd like to make a motion for me to appear under Court Rule 8.120. I have the Assistant Prosecutor, Ms. Andrea McCray, Supervisor.
Thank you.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Mr. Usama Iwabata, who is not present. He is no longer in the country.
Your motion is granted. Thank you. He's not in the country because of what?
He got deported, Your Honor.
Indefinitely?
I would assume so. That kind of deportation is a minimum of 5 or 10 years before they can return.
Okay.
He was deported to Palestine. I don't know how that's going to look for him.
We'll leave that to the prosecution to verify. And once they verify, they can, or if it's up, if they want to verify, they can make any motions that they want to make.
Your Honor, the people would move to dismiss. We did receive an email correspondence with a letter suggesting that he was confirming that he was deported or set to be deported today.
Okay, are you talking about the letter that came from the defense attorney?
Correct.
Okay, so you're moving to dismiss with or without prejudice?
That would be with prejudice.
With prejudice?
Yes, sir.
The motion is granted. We'll provide you a now. Additional matters for the record.
Nothing further from the people.
Enough for defense. Thank you, Your Honor.
You're welcome. For the record, in the matter of the people of the state of Michigan versus Travis Luther. File number 23-00734. Council appearance.
Good
morning, Your Honor. Case Markarian appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Travis Luther, who is present and standing to my right.
Okay, how are you, Mr. Luther? I can hear. I'm sorry? I couldn't hear.
Yes.
How are you?
Oh, good. How are you, ma'am?
I'm doing well, thank you. Today's the date and time that was set for a final pre-trial. I have a plea sheet here. It says that you're pleading guilty to an admitted count 1 of impeding traffic.
Does it say pleading guilty for their responsibility?
Oh,
This is plea to amended count of
It should
impeding
say
traffic, so that's a
um,
civil infraction, correct?
right, Your Honor, my apologies. Andrea McCray appearing on behalf of the people. That should say, wait, what is the wording? Admitting responsibility, my apologies.
Sounds good, and if people will dismiss. Count 2, however, I believe that the state prefers to add a count and not amend. So that's part of my confusion. So you're going to accept responsibility to an added count 3 of impeding, is that correct? Excuse me, can you tell them to turn that down? I should not know word for word what's going on in that courtroom. Okay, sounds good. And counts 1 and 2 will be dismissed, correct?
Correct, Your Honor.
Okay. Fine is $130. When can you make payment?
I believe within 2 weeks.
Are you employed?
Yes, ma'am.
Where are you employed?
LaFontaine, Buick, GMC.
Okay. And you didn't come with $130 to pay this fine today when you were, it's a heck of a deal to get this resolved. You didn't come.
Not with 130, not with me, ma'am,
Okay,
no.
what do you have with you?
Sure, $100.
Okay, you're gonna make some payment today? Are you able to make some payment today?
Yeah, yes, I can make some.
How much can you pay today?
I'm sure I can give $100.
And when are you gonna pay the balance? Within 2 weeks?
Yes.
No. Get you over to the counter, you can make your $100 payment, you can pay the balance within 2 weeks. That will resolve this matter. Any additional matters for the record, counsel?
Nothing further from the people. Thank you.
Nothing for defense. Thank you, Your Honor.
On the record in the matter of the people of the state of Michigan versus Kazamali Pekar, file number 23-00987. Counsel Terrence.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Kazim Ali Paikar, who is present and standing to my right.
As being the date set for a final pretrial, I do have a plea sheet here. It says the people are offering Mr. Pekar for you to plead to an added count. Actually, plead guilty to count 2 of domestic violence. The misdemeanor maximum penalty is 93 days in jail and or $500 in fines, and that the people will dismiss count 1. And there's no objection to 769.4A if eligible. And there's a Killebrew agreement of no upfront jail. Is that what you understand your offer to be, sir?
Yes, sir.
Okay. I have a advice of rights and plea information sheet. Did you read this document?
Yeah, that's correct.
That's your signature on there?
Yes, that's correct.
Okay, let me have you raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
Thank you. You can put your hand down. You understand, sir, that in order to accept the offer, which is for you to plead guilty to count 2, and that people will dismiss count 1, that you would need to waive each of the rights listed here. Okay, so that means you would waive your right to have a trial. You have the right to have a jury trial. At the time of trial, you have the right to the presumption of innocence, so you're innocent until proven guilty. And you have the right to have the people prove you guilty by proving each element of the charge being brought against you. You have to prove each element at a jury trial beyond a reasonable doubt. You understand that?
Yes, sir.
Okay, you have the right to see, hear, or question any other witnesses that the prosecution intends to call. You have the right to call your own witnesses to trial or present evidence at trial you believe would further a defense to the charges being brought against you. You understand that? And you're willing to waive all of those rights today?
Yes.
You're willing to waive your presumption of innocence? You're innocent until proven guilty. You recognize that?
Yes.
And you have the right to remain silent at trial and not have silence be used against you. You understand that?
Yes.
Anybody make any promises to you to get you to waive your rights and plead guilty?
No.
Has there been any threats made to you in exchange for a guilty plea?
This is my decision.
It's your decision. No one's threatening you.
No.
Are you currently on probation or parole?
Yes.
Which one?
I don't believe that you're on probation.
No, you're done.
Okay. Yeah, well, I asked you, are you currently on probation or
No.
parole? Okay, very good. Okay. You understand that a guilty plea can result in a conviction that may have an impact on any immigration or travel status you may be seeking? Okay, you understand that?
Yes, sir.
Okay, it also could result in the conviction that you may need to report to your current employer, or you may need to report in a conviction to a future employer. You understand that? There's a Killebrew agreement. That's a sentencing agreement. That's between you and the prosecutor. I'm not a party to that. Do you understand that?
Yes.
So if at the time of your sentencing, I decide that it's in the interest of justice that you serve jail time, I have the right to sentence you to that under the law, but I would give you the opportunity then to withdraw your plea, okay?
Okay.
Do you have any questions about that this time?
No, sir.
Are you entering a guilty plea because you believe you're guilty?
Yes, it's my,
As to count 2 of domestic violence, how do you plead?
yes,
That wasn't my question. Do you understand my questions?
You're changing your plea at this time, so you, instead of not guilty, you have to change. If you
Well,
change-
I'm gonna ask him a question. I want to make sure he understands what I'm saying. Do you understand my question?
yes,
Okay. As to the charge of domestic violence, how do you plead? Are you pleading guilty, not guilty, or standing mute?
no, it's my guilt,
I'm sorry?
it's guilt.
You're pleading guilty. Thank you. Factual basis.
Thank you, Your Honor. All right, Mr. Pikar, on March 24th of this year, 2023, were you at your home at 3909 Richmond in the city of Lansing, Ingham County, state of Michigan?
Yes, I,
And in your home on that date, did you assault your spouse, Fatima Batul?
yes,
All right, and on that day and time and place, you hit her on the back?
yes, in fact,
Was it with a closed or open hand?
open.
Your Honor, I have no further questions.
Any questions from the prosecution?
Yes, Your Honor, just a couple. Mr. Paycart, she didn't ask you to hit her, right? And it wasn't out of self-defense?
Was it in self-defense that you hit her?
No,
People are satisfied with the factual basis.
Okay, the court is also satisfied with the factual basis. I'll accept your plea. Find your plea to remain freely, voluntarily, and intelligently. This matter is set for sentencing. Sentencing is going to be July 17th at 8:30 in the morning. When you leave here today, you can go downstairs to the 5th floor to our probation department so they can get you set up for a pre-sentence report investigation so that that can be provided to the court with a recommendation about how you should be sentenced, okay?
I'll wait for your notes to appear and then go downstairs.
No, I haven't dismissed you
Oh,
yet.
I'm sorry.
This is my court. Okay, thank you. Do you have any questions for the court?
no, it's just,
Okay, any additional matters for the record?
Nothing further from the people, thank you.
And nothing for defense. Thank you, Your Honor.
Thank you. Now you can have a seat. Did Miracle Roper appear?
Yes, Your Honor. Is there a referral form for downstairs?
On the record in the matter of the people of the state of Michigan versus Miracle Divine Roper, file number 23-01001. Counsel appearance.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Miracle Rover, who is present and standing to my right.
How are you, Ms. Roper? Today's the date and the time that's set for a final pre-trial. I also have a PA 53 violation here.
When you come back and I see you, we'll know and we'll wait for this trial to be.
Okay. The allegation is that you violated, ma'am, the terms and conditions of your bond by having direct or third party contact with the alleged victim in this matter. So you have the right to have a contested hearing. You have the right to be represented by counsel during that hearing. You have the right to cross-examine any of the witnesses that are brought to that hearing to testify as to the allegation that you violated the terms and conditions of your probation. Do you understand that?
Yeah.
If you're found to be in violation of your bond conditions, your bond could be revoked pending ultimate decision on this case. You understand that? Okay, you also could be sentenced to a contempt of court, which is a maximum penalty of 93 days in jail and or up to $7,500 in fines. Do you understand that? How does she want to plead?
She's pleading not guilty. Your Honor.
Is the victim here today?
Yes, Your Honor.
Okay, so then we can proceed to a hearing on this today, correct?
Your Honor, Ms. Roper has informed me that she has a witness that she would like to be here to present their testimony who was with her that day. I just learned of this today, so I want, and there is, we're also here for a final pretrial. There was an offer extended, but at this time, we just want to continue it on to jury trial.
What's the offer?
The offer on this case, Your Honor, would be to plead to count 1, domestic violence under 76948 if eligible.
Count on the original charge,
Yeah,
so there's no offer. Correct?
76948.
You can't offer 769, correct? Just to be eligible. Nonetheless, okay, so there's no offer. So this, and the reason why I asked that is because I only keep offers open until today. So there's no offer. So you can plead up to the time that we call a jury in, if that's what you decide that you want to do. So we're gonna hold the PA 53 at the time of the jury trial.
Your Honor, I don't prefer that. I would prefer to have it ahead of time, but I don't know exactly how much time on our docket we have before then. So, and if there is.
I'll let Ms. Nash advise us to that. She knows better than I do.
For the jury trial date?
Yeah, because that's June 26th.
Yeah.
I
mean, for a hearing, we can always, that's fine with you, just put it on. The attorneys are gonna be here. Thursday, Friday.
They could do it, it could be a Thursday or Friday. They're here then.
Would you guys need 2 weeks to subpoena? What do we have in the morning? Messages. So these two attached to. Yeah, can't do it. Okay. Oh, wait, what's going on? You said 2. Yeah, this is 2. Oh. The 12? Yep. 12 at 9:30.
Okay, June 12th at 9:30. I'll continue bond at this time. Immediate threat. Any additional matters at this time?
Nothing further from the people. Thank you.
And nothing for defense, thank you, Your Honor.
We'll get you a copy to appear, a notice to appear for June 12th, okay? And then your trial will continue on June 26th at 8 8 AM, okay? Mr. Lee, I didn't see you hiding back there.
Hi.
Okay, let's see. We're on the record in the matter of the people of this state of Michigan versus Melinda Sue Wirt. Our number is 23-01021, council appearance.
Good morning, Your Honor. Case Mark Hearing, appearing on behalf of the people.
Assistant Public Defender Sarah Dowling on behalf of the defendant Melinda Wirt, who was present and standing to my right.
How are you, Ms. Wirt?
I'm all right. How are you?
Doing pretty good. Today was the date and the time set for final pretrial. I have a nollie here. It says the people are unable to proceed because the necessary witnesses failed to appear. So they're moving to dismiss without prejudice. That simply means that the case will be dismissed today. However, they do have the right to reissue the charge against you if the necessary witness later re-engages with the prosecution is ready to proceed within the statutory time period. Do you understand that?
Yes.
Any questions about that at this time?
No.
Your copy of the nollie. Any additional matters for the record?
Nothing further from the people. Thank you.
Nothing from the defense. Thank you.
Thank you. You're all set.
Thank you.
Okay, got a few people here from the jail. Okay. Who's in the jail post 2?
Nicholas Gage,
Nicholas Gage. He's actually in post 1. Who's in post 2? Who's the other gentleman from the jail? Sir,
Miller.
it looks like you have a pencil in your ear. Can you hear me?
sorry, Michael Miller.
Thank you. Both are here for show cause, ironically. Give me just a moment, please. Okay, Kelsey Alvarado. Not sure what's going on.
Yes, Your Honor.
Okay. Okay, we're on the record in the matter of the people of the state of Michigan versus Kelsey Alvarado, file number 19-04939, council appearance.
Matthew Samuels on behalf of Mr. Alvarado. We're both present via Zoom, and we waive any right to any in-person hearing at this time.
Date and time that was set for a sentencing. What do I have this here? Okay, that was the bond. Okay, set for sentencing, and we do have a pre-sentence report prepared February, February. I'm reading backwards today. It's prepared May 2nd, 2023. Did you get a copy of that, Mr. Samuels?
I did not, Your Honor. I was just looking through my emails and I never got it from probation.
Okay, I'll have someone scan it to you right now so you can review that with your client. Did you want me to reset this? Or did you just want to talk to her in a breakout room?
That would be wonderful, Your Honor. Thank you.
Okay.
No, we can reschedule this.
Okay. Let me get a new date. Yeah, I'll give you the whole file in just a minute. You can add a slide if necessary. Does May 30th work for you?
It does not, Your Honor.
Okay, I think we lost Miss Alvarado. I don't see her. Oh, there she goes. June 1st.
Sorry.
It's there.
June 1st work. Oh, and I don't see him. Something's going on with people's signals today. Samuels, can you hear me? Okay, so we lost him too.
Now I can hear you. Yeah, I can hear you.
Okay, very good. What about June
I
1st?
apologize. June 1st
No,
does not work either. I apologize.
Okay. Okay, are you on vacation?
Me?
Because we're just gonna ask you for the next day.
No, I'm not on vacation. I just,
Okay,
by
so what about June
conflict,
2nd?
Yeah, I can make June 2nd work, Your Honor.
2nd at 8:30.
Thank you very much.
No problem, and we'll get probation to send that over to you today.
Thank you.
Okay, I can't hear you. Your signal is sketchy right now. It's going in and out.
Is this better, Your Honor? I apologize. I'm in 55A right now, or 55.
Okay. 55th, okay, sounds good. That's better. Ms. Alvarado, did you get your next court date?
June 2nd at 8:30 in the morning.
That's correct.
Okay, and then I know that today was probation, so I know that I'm working today. So did you guys need me to report there tomorrow, or do I just wait until that next court date?
You said you know that today was probation?
Yeah, it said on my court paper that it said sentencing /PROB. That's why I thought that it was for probation today.
Oh, you have a probation violation. That might be why it said that.
Okay.
But that violation is essentially that you have a new case pending, so.
Okay, yeah, that's for circuit court.
That's what that means, with sentence /pro.
Yes, there's something.
Oh, okay. Yep, you're all set. You don't have to refer to probation on this today, okay?
Okay, thank you so much, Your Honor.
You're welcome.
Have a good day.
Same to you. Corey Goss. Who's that? I'm not sure. We're on the record in the matter of the people of the state of Michigan versus Nicholas Cottle, file number 22-03366. Council appearance, that was Council Alvarado.
Morning, Your Honor. Michael Joliet, P 32086 for the defendant, who's present on Zoom.
Okay, Mr. Cottle, can you hear us?
Yes, Your Honor, I can.
Okay, today's the date and the time that was set for a sentencing. I do have a pre-sentence report and a recommendation. Mr. Joliet, did you get a copy of this report prepared on May 16th, 2023?
I did, Your Honor, and I forwarded a copy to my client, and we met and reviewed it in detail yesterday.
Okay, any objections, corrections, or deletions that need to be made?
I don't believe so, Your Honor.
Okay, you can proceed to allocution.
Judge, I reviewed the report, Mr. Cottle, because I've had some experience with him on some of his earlier cases that are mentioned in the pre-sentence report. He's struggled to stay clean. He's been inpatient. He's been intensive outpatient. He's a methadone clinic patient. In order to try to get things back on track, he moved back in with his father, away from Lansing, where he seemed to be exposed to some elements that that caused him to relapse. He's currently employed. In fact, he's on his way to work today in construction. He's been actively participating in one-on-one therapy, in group therapy, attending daily or multiple times each week AA and NA meetings, the AA meetings sometimes with his father. In our long conversation, he realizes he's been wasting his potential. He's a high school graduate, has an associate's degree, from community college. And he's committed to maintaining his sobriety and staying clean. And he anticipates moving back to the Flint area permanently because he has a pretty good construction job currently. And that gives some structure to his life because he's working every day and avoiding trouble. He doesn't have access to a motor vehicle anymore, so he can't drive. He's using the buses for transportation in town and arranges Uber or Lyft transportation to fill in the gaps between mass transit and his father's transportation. I agree with the recommendation and I'm hopefully that he can comply with all the terms and conditions and he knows the consequences if he doesn't.
Thank you. Does your client wish to make a statement at all on his own?
Mr. Cottle?
Yes,
Do you have anything to add to my statement?
just that I agree 100%, and I would like to thank Your Honor and you, Mr. Joliet, for this opportunity, and that I have the utmost confidence that I can get clean and stay clean. I had, 4 years of clean time from all substances in the past, and it was a struggle to get back into recovery, but now that I'm back, I look forward to excelling and moving on and putting this part of my life in the past.
Thank you, Nick.
Thank you.
Thank you. So I've had an opportunity to review the pre-sentence report, the substance abuse assessment, and your prior criminal history. I mean, I think that goes without saying that you definitely need some assistance, sir. It's stated here in the report that you met the criteria for a severe opioid use disorder. And so that's something that must be addressed if you're going to have long-term success. And I understand that in recognizing you and your attorney have indicated that you've gotten back into some treatment. I'm not sure how extensive that treatment is, but the recommendation of the court or of the probation department is for you to do a 18-month term of probation with some intensive outpatient substance abuse treatment. And so I think that's the most appropriate method or mechanism at this point, and to try to address the severe opioid issue.
Sorry, I got interrupted by something.
Yeah, someone entered in their device is creating some feedback. So I apologize.
No,
I said
no problem. I heard you. My concern is that I always thought that intensive outpatient took away your ability to work a job. First, traditional outpatient, which I'm doing now in a more extensive form, which allows me to meet. I meet with a counselor one-on-one every week for an hour, and I also meet for a group therapy for an hour and a half once a week, as well as attending almost daily NA and AA meetings.
okay.
I'm willing
What it
to
sounds
do.
like, I do have Mr. Hannah here in the courtroom today. So, and he just indicated to me that what you just described is intensive.
Oh, so the things I'm doing now are intensive.
That's what he stated.
Oh, all right, perfect.
Okay, so it would not be the goal of the court to take you away from employment. We recognize and encourage and also order maintaining employment because that's typically one of the avenues to help you maintain a healthy lifestyle. Excuse me. And so with that being said, it does sound like you may already be doing or what you're supposed to be doing. You're already on the right track. So hopefully this court order will be a breeze for you because I am going to adopt the recommendation of probation. And so you will be sentenced to a term of 18 months probation while on probation. And I will update this because it does state that you were unemployed. You are employed now?
Yes, ma'am.
Okay, where are you employed?
Ken's Remodeling.
Okay, so while on probation, sir, I am going to order that you attend a 12-step program and provide verification to your probation officer as directed by probation. I'm going to order that you attend a victim impact panel within 90 days and provide verification to the probation department.
Not a problem.
You're going to continue your rehabilitative services, which is the intensive outpatient treatment. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol, marijuana, or any other controlled substance unless you have a valid prescription. Do you understand that?
I do.
You will be required to submit to random preliminary breath tests and/or urinalysis testing. You are responsible for the cost associated with that.
Understood.
Okay, very good. But in order that you maintain employment and provide verification to probation, you're not to be at any bars or nightclubs while on probation. Do you understand that?
I do, Your Honor.
Okay. Okay. While on probation is a $30 per month oversight fee that you're responsible for, okay?
Yes, ma'am.
There's a $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost that also must be assessed. You owe $289.85 to the Lansing Police Department for OWI cost recovery.
Okay. Do I pay that directly? Can I call the police department to pay that? Or do I have to
No,
pay
you'll
it
pay
first?
that through the court. It's ordered
Oh,
by, through court order by restitution, but give me just a moment.
sorry.
No problem. $30 per month. Oversight fee for 18 months is $540 for probation oversight fees. I'm gonna waive discretionary fines and costs at this time. So your probation fees plus your OWI cost recovery plus the crime victim rights and state minimum costs will amount to a total of $954.85.
And that's the total cost of my probation altogether, correct? Or am I misunderstanding?
The cost for probation is gonna be $540 because it's $30 per month. But you
No, I
also have
mean-
a $289.85 restitution to the Lansing Police Department plus some fines and costs that are
That was,
crime to rights fee and state minimum costs. And so the total, sir, that amount that I gave you, that is the total that you'll be making payments on. And your probation officer will advise you of what your monthly payment would be in order to satisfy your probationary terms, okay?
okay.
Do you have any questions about the fines and costs at this time?
No, ma'am.
Last but not least, there's an advice of rights as to probation. It states you have been sentenced to a term of probation in the 54A District Court. The probation terms have been individually tailored and are specific to address your assessed risks and needs. Except for domestic violence, criminal sex crime, and stalking offenses, or an offense where the defense of guilty but mentally ill was asserted, you may be eligible for early discharge from probation. You have the following rights. You have the right to request early discharge from probation once you completed half the original term ordered by the judge. Your probation officer may, but is not required to, file a notice with the judge once you become eligible for early discharge. The probation officer must send to you and the prosecuting attorney a copy of the notice. The prosecuting attorney has 14 days after receipt of the notice to file written objections to early discharge. You may make an early discharge request from probation after meeting the following conditions. 1, you have completed all the required probationary programming, and 2, you have not violated probation within the 3 months prior to your request. You must send a copy of your request for early discharge from probation to the probation officer and the prosecuting attorney. The prosecuting attorney would then have 14 days from receipt of the notice to file any objections to early discharge. If a hearing is scheduled, you have the right to hire or retain an attorney to represent you for that hearing. You do not have the right to have court-appointed counsel represent you at the hearing for early discharge. You may make your request for early discharge by completing the notice regarding eligibility for early discharge from probation. That's the MC 512 form. That form is available on the court's website, or you can ask your probation officer to provide you with that form if necessary, okay?
Yes, ma'am. Thank you for your time, and I appreciate the opportunity.
Thank you. Do you have any questions at this time?
I do not.
I have one
Additional
question.
matters?
I have one question, Judge.
Yes, sir. Yes, sir.
Just with respect to the random drug testing, since he's living in Genesee County now and doesn't have a vehicle, I was wondering if the probation is a reciprocal or an acceptable drug testing facility in Genesee County.
Yep, they'll work that out to make sure he's testing in the county where he lives.
Great. Thank you very much, Judge.
No problem. Any additional questions or matters for the record?
No, Your Honor, not for me. Thank you very much.
Thank you. You're all set, and good luck to you, Mr. Cottle.
Thank you, Your Honor.
Nicholas Gage, I did not. Let's see. We're on the record in the matter of the people of the state of Michigan versus Nicholas Gage, file number 20-026228. Mr. Gage, this matter was set for show cause. Excuse me, because you owed $150. Let's see. What are you in custody for, sir?
My tether broke on me, and unfortunately, they didn't believe me, so I have a bond violation.
Okay.
Yep, still waiting a trial.
You're waiting a trial or a hearing on the bond violation?
I saw the hearing, they denied me release, so I'm waiting trial June 28th is when the trial starts.
Okay. Is that in this court? Which court is that in, sir?
That's a circuit court.
Circuit Court, okay.
He actually granted me that bond a long time ago.
Sounds like you've got greater issues to address. I'm gonna waive the fine on that and close the file. You're all set.
Yep, thank you.
Excuse me. We're on the record in the matter of the people of the state of Michigan versus Michael Miller, file number 20-01439R1. Okay, Mr. Miller, today was the date set for show cause because you owe $90. A disorderly person from 2020. What are you in custody for, sir?
A few things, OWI, driving no ops, and that's a Mason. I have a drunken disorderly and another drunken disorderly. And I got a probationary hearing the 6th of next month, downtown Lansing.
Okay.
And all failed to appears.
Okay, I have no interest in keeping this file open anymore. I'm gonna waive the fine and close the file. You're all set.
Thank you.
Thank you. Was Corey Goss supposed to be here today? Is that what you're here for?
Yes, Your Honor.
Is he supposed to be here today?
I hope not.
You didn't mean that, right? No? Well, I don't know. Where should he be?
It's a review of his mental health status. Your Honor.
Gotcha. This is old. Let's see. Anybody give us an update?
Yes, we did receive an update from the forensic center. He has been found incompetent. He had that here in a second. And since then, we did receive a notice that they recommend inpatient treatment to bring him back to competency, but they don't have any beds available. They're just putting us on notice. It might be a long time before he gets a place to live.
Does he have another file?
I think he has one with Sarah Donnelly.
And before me?
Yes.
That then this note should have just, that note could have been updated on this versus another court date, because I don't have anything on here since the 17th of April. We found him incompetent on which file?
Felony.
03656.
Yes.
And he's awaiting a bed.
Yes, Your Honor.
You set this for the same date as felony, whatever's going on with that, so that we don't know where Mr. Goss is. No.
That's true.
Okay, well, then we'll put him in warrant status.
I think he's already on the right status.
Is he?
He failed to appear last.
Oh, no, the problem is that these files were not together. So this should have been in warrant status.
Great.
But it was not. So we'll get him a warrant status on that one. Thank you.
Thank you, Your Honor.
Have a good one. Okay. Who's in the jail?
Tanner.
Who?
Joshua Tanner.
Thank you. Joshua Tanner. Who's his attorney? Did they just go?
Yeah, case, one of his files, so I had to get it.
Oh, I'm not actually calling the case.
Oh.
I think he needs, I don't know whose attorney is. Mr. Lee, does he need to talk to him? Let's see if his attorney needs to talk to him, but Mr. Lee walked out, so. Need to speak to him?
No, we're ready for some cash.
I'm not ready to proceed on that yet. Mr. Chairman, I'm gonna put you in the waiting room until I'm ready to proceed with your case, okay?
Yes, ma'am.
Thank you. No, you're fine. It's because I have other people on Zoom. I can't proceed with that. Okay. Who's representing? Actually, ma'am, what's your name?
Sandra, I.
Sandra, I. Dog license vaccination. Does she have an attorney? On that one? We're on the record of the matter of the people of the state of Michigan versus Sandra K. I, file number 23-00971, council appearance.
Morning, Your Honor. Case Mark Marion appearing on behalf of the people.
Assistant Public Defender John Lee appearing on behalf of Sandra Hyde.
Today was the date and the time that was set for a pre-trial on a dog license vaccination. How are we proceeding?
Yes, Your Honor. We were provided proof from defense counsel and Ms. Hyde of her getting the dog license properly fixed. So it's time that people would move to dismiss.
Motion to dismiss is granted. Your matter is dismissed, ma'am, okay?
Okay, thank you.
You're welcome. Okay, and then Emmanuel Monzon, who's representing him? Are you ready on him? Dog at large.
Sarah Down.
Okay.
Not sure what the status of that.
We'll see if Ms. Donnelly needs to speak to him. Ms. Ide, you're free to go. Okay, Mr. Samuels is here with Ms. Perkins. Let's see. We're on the record in the matter of the people of the state of Michigan versus Jasmine K. Perkins, file number 23-00393. Excuse me, council appearance.
Matthew Samuels on behalf of Jasmine Perkins. We're both present via Zoom and we waive any right to any in-person hearing at this time.
Prosecutor's appearance on this one.
Good morning, Your Honor. Case Mark Marion appearing on behalf of the people.
Thank you. This was the date that was reset for a show cause because the court ordered for the victim in this matter, Michael Hill, to provide a time for which Ms. Perkins could obtain her personal items from the property. At our last hearing, I believe the court was advised that the victim threw the defendant's personal property in the trash, that the defendant wanted some dishes, and the defendant was ordered to appear today to advise what items she believes are missing from her personal property.
Ms. Perkins,
Yeah,
did you make that list of things that were
yes, I
missing from your
did.
personal property?
I did. I just need to find the paper because it got misplaced. So I just
So how
need
are
to
we?
find it.
Okay, well, we need to know what you're missing.
I can tell you everything that I am missing. A pump that I just got a couple years ago that I haven't been able to use. I know how much that
You say a
is.
cup?
No, an insulin pump.
A pump, insulin pump.
And that I know is over $10,000. I'm missing some clothes, the dishes, yeah, clothes, dishes, the insulin pump, pictures that I can't get back because they're of people that have passed away. I had a whole list of stuff written down, but those are the main things that I know that got thrown away.
Okay. Prosecution's victim is here. Can you advise if your victim has any of the possession of any of these items that were in the property?
Does that give me permission to
I'm
speak?
talking to the prosecutor.
Oh, come on, guys.
Yeah, just one second. I just need to check.
So,
Ms. Donnelly, did you need to speak to Mr. Malzahn?
I do not, Your Honor.
Your Honor, on Perkins.
Yes.
So he had his father, Mark Pierce, reach out in the last week or two, set up a time with Miss Perkins to pick up the stuff. She has not set up time to pick up some of the stuff yet. What he does have possession of still are her dishes and some miscellaneous items and totes, things like that.
Your Honor, since we were under court order, I did advise Miss Perkins not to respond to that text message. When we were here from the last hearing, we were under the impression that all her stuff has been tossed. And based on, and I did submit some other text messages to the court, based upon those text messages, it sounded like they were just using that as a prerequisite to get Miss Perkins to violate the court order so that they can contact the police like they've done previously.
Okay, well, I don't, if you did send it to the court, I don't know that I have them, but nonetheless, it does sound like she does have some items that are still within the possession of that property. I will leave it to prosecution to coordinate with Mr. Samuels to get a time for Ms. Perkins to get her items, inventory those items, and make sure valuables are recovered. And then Mr. Samuels, I guess whatever has been discarded of unlawfully by the occupant, you'd have to pursue an action for that on behalf of your client.
Okay. Since I am court appointed, I don't believe that I can do that, but I will advise my client as the best way of proceeding.
Sounds good.
Your Honor, there is one thing I would like to address.
Here, did the prosecutor get a copy of these text messages? I think
that I know of.
They were sent to Mr. Ring, it looks like.
Yes, I did send them to Mr. Ring.
I don't have any messages on the file. Might not have transferred them over.
We'll get you a copy of them.
Thank you.
This was addressed at the last court hearing, Your Honor, and you asked me to give you proof of those so that we can address it at the next one.
Very good. The prosecution is in possession of some text messages. I reviewed these text messages. This is a disgusting display, to say the least. There was a no contact order that was for the protection of the victim, but it looks like, based on these text messages, the victim took an opportunity to taunt and harass Ms. Perkins by way of his father, and that the victim took it upon himself to engage in an unlawful eviction by discarding Ms. Perkins' property, and to the best of the court's information, which is information provided to the court at the time of Ms. Perkins' arraignment, was that her name was lawfully on the lease for this property, which means that a lawful eviction would have been required before things could be discarded of. And I don't know that there was an eviction that went through the 54A District Court that allowed a writ of execution to allow anyone to remove property and or personal belongings from the property that belonged to Ms. K. Perkins. The court ordered back in February to allow the defendant to be able to make arrangements to get her property. Court was not notified until May that there were some items that was discarded of. If items were discarded of, those things could have been, or that could have been addressed back in February when the victim was here, but that didn't happen. Again, it would be up to Ms. Perkins if she wants to pursue anything against the defendant and or the defendant's father, who I believe was the author of these text messages with the phone number ending in 1700, as to the recovery of any of her personal items that have been improperly discarded of. Hopefully, the victim and the victim's father are no longer contacting Ms. Perkins, because that would be ridiculous. But as it relates
As of
to
last
court-
week, there was contact made, Your Honor.
It's completely ridiculous, Ms. Perkins, and I don't know if you have a smartphone, but I think you should block them if that's the case. Block the numbers.
Your Honor, I would also ask to have the no contact order removed. These aren't people that are looking for protection. This is people using that no contact order to harass Ms. Perkins. Clearly, because if you look at one of the text messages, when she pretty much said, "This is harassment, please stop," he said, "Okay, now you're in violation of the order and you're going to prison."
Yeah, I see that message. This is a message that I believe came from the victim's father.
Correct. But these aren't,
Who's not-
I mean, and it came through the victim
She
as
doesn't-
well.
Right, but I get that, but there's a no contact order, meaning that she can't have third-party contact with the defendant. But if she gets a text message from the defendant's father and she responds back to him, she's not sending a message to the father to send to the victim. She can directly respond to the father, don't contact my phone, don't harass me, or go to hell, whatever she wants to say to him if he's contacting her. She just can't send a message to Mr. Hill through the father. Okay, if the father and Mr. Hill continues to harass her, she should call the police because she clearly has evidence in written form of harassment. And it sounds like evidence that they've discarded of some of her personal items, whereby she may have the right to a financial recovery. So I'm not going to
Understood, Your Honor.
contact order. Mr. Hill is in the courtroom. Mr. Hill, it would make no sense for you to contact or have your father to contact her. Do you understand that?
Yes, I understand that, Your Honor. It's not me contacting her, it's my father.
Okay, but it will make no sense. You tell your father to stop contacting her.
I will. And then also, just to put this in the record, just for that.
I didn't ask you to put anything in my record.
Okay, well, I was.
I asked you to tell your father to stop contacting her.
Yes, ma'am.
That's the order of the court on that. Any additional matters for the record today?
Nothing further.
Nothing, Your Honor. Thank you very much.
Thank you. You're all set.
It's still my phone. That's MICHEO.
Who's on the Samsung SM?
That's what was.
It's the city of Lansing case. This was all screwed up. What's happening?
Paul Escochea too, the
Who?
Paul Escochea was supposed to be rated from Eaton County and he's a city case. Okay, yeah.
Yeah, but he's a city
Yeah,
case. Where is it?
we need to figure.
The city case. We don't have a city attorney here.
I don't know. We need to figure out.
Not that we can't get a city attorney. They're just downstairs. I'm trying to see. There's somebody else in the jails. You say you did not need to speak to Mr.
No, I did
Monzon?
not. Yeah, Mr. Monzon, he's the animal dog at large. I don't know what kind of proof you want, but he just basically had this dogs, keeps it on tether inside of his fence. And like electric collar?
Those
No,
comments
I
are
think it's
crazy.
regular
I just
collar,
went and
that
looked at
they
it.
slipped, so he bought a new one, there's two. Bought a new one for his dog.
Hello? Hello? Yeah, hello, hi there.
That it slipped its tether, and so we replaced the collar, but I don't know, like, but definitely. And he hasn't any incidents since then. I don't know, but I don't know why you wanna- We wanna get proof on
Where?
that.
Must be in the hallway.
Stop
Oh, yeah,
it.
pictures?
Get the heck out of here.
Yeah.
Somebody get Mr. Abbott on the
Yeah,
line.
like, I'll get photos.
Corey Goss is in the
Okay.
building.
We have some. Yeah, sure, I understand.
Do you have Mr. Abbott's number in that phone?
Yes, I
You
do.
text him and say Corey Goss is in the building.
Oh,
There's
nice.
something he's got in the bottom of the bush that goes down, anything like that?
want his file back?
Yes,
Okay.
I think they might have the other one. Bailey just, if you go see Bailey.
Yeah,
Yeah, because he has a felony, I
Okay.
think.
Okay, we're on the record in the matter of the people of the state of Michigan versus Emmanuel Monzon, file number 23-00974, council appearance.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, who is appearing separately by Zoom.
Today's the date and the time that was set for pretrial on a dog at large. How are we proceeding?
Your Honor, at this time, Mr. Monzon has reported the efforts that he has made to correct the issue of his dog getting at large. At this time, the prosecutors would like me to provide them photographic proof of Mr. Monzon's backyard. So if we could get a brief adjournment, I will get those pictures to the prosecutor's office.
June 12th.
June 12th at 9:30. Do you have any questions for the court today, Mr. Monzon? Mr. Monzon, you're muted.
Can you hear me now?
I can hear you now, sir. Do you have any questions?
I do not.
Okay, you're all set. Thank you. Is Joshua Tanner here? Oh, he's in the breakout room, that's why. Okay. Jasmine Perkins, we took care of. James Little? Is James Little present? Okay, Big Schwartz. Stephanie Lewis present. Big Schwartz. You said, do we see Reginald Baldwin?
Your Honor, Reginald Baldwin is still at the center according to his wife. He should have, they say that he could be released in 3 to 4 weeks. He was found not guilty
I
by
see
reason of
that now.
insanity, yeah.
Reset this 30 days. You can do it after the fact. Just get rid of it. Is Paul Escochia here? I don't know who's in the jail. Is that Mr. Zarka?
Yeah.
It's Mr. Zarka in the jail. Okay.
Escochia is supposed to be in Eaton County.
Oh, I do see that. You said he might be downstairs and we probably need a city attorney, so we'll deal with that later. Okay, who's on the Samsung SM, sir? Sir? In the Samsung SM,
Yeah,
what's your name?
Matthew Torres.
Matthew Torres.
I do have Mr. Torres. I would like to speak with him in a breakout room, Your Honor.
Okay, give me just a moment, make sure you don't have anybody else here. Who's representing Dunwoody Moore?
I am, Your Honor.
Do you need to speak with him?
No, I do not need to speak with him.
We're on the record in the matter of the people of the state of Michigan versus Marianne Dunwoody Moore, file number 23-00839 SM, council appearance.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
An Assistant Public Defender Sarah Donnelly on behalf of the defendant, Maureen Dunwoody Moore, who is appearing separately by Zoom.
Thank you. Today's the date and the time that was set for a pre-trial. think we reset it because there was additional discovery being sought. Did you receive that discovery?
Your Honor, off the top of my head, I can't
Or it
recall
was
what
additional
you.
time review of the discovery, not receipt.
Yes,
discovery?
review it. I did review it with him.
Okay.
At this time, I believe that we're still looking for some sort of offer. There might be a global resolution he has. What we really need to do is reach out to Ron Barry, the other attorney on his other conflicted out cases, to make sure that we're on the same page in regards to him.
It has a matter of circuit pending still?
Yes, he has a.
I think I handled it here. Okay. So where's the circuit court matter stage? You know?
I believe they're waiting for, I thought they were
Trial
waiting for a
date.
jury trial, yeah. But yeah, if the state is willing to offer some sort of global resolution, I just want to be on the same page with him.
Okay, so how much time are you looking to have this reset?
Not too long, the next court date should be fine, Your Honor.
I could add a slot. So June 12th at 9:30. Do you have any questions for the court today, Mr. Dunwoody Moore?
No, ma'am.
Any additional matters for the record, counsel?
Nothing further from the people. Thank you.
Nothing for defense, thank you, Your Honor.
You're all set for today, sir. Go for a motion. Motions here. Okay, I think now's a good time for you to go and meet with, oh wait, who is this? Oh, that's Mr. Nagel's client, I believe. Okay. Mr. Nagel, are you here with Katina Newton?
I am, Your Honor.
Schedule these like this. Let's see. Could someone see if we can get a city attorney to handle Escuchilla? And then what happens to Mr. Lee? What are we doing with Mr. Zarka?
Mr. Zarka's case should be dismissed. He's gonna be put into drug court at a plea and sentencing before Greenwald on June 28th. So I'm expecting the prosecutors to dismiss this case after that.
Oh, so reset it until after that. July 10th at 10. July 10th at 10. Mr. Zarka, you're all set on this matter for today. We'll see you July 10th at 10.
All right, thank you.
You're welcome. You need to be meeting with him again?
Yeah, Mr. Torres.
On the record in the matter, the people of the state of Michigan versus Katina Newton, file number 23-01190, council appearance.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
Good morning, Your Honor. Matt Nagel on behalf of Ms. Katina Newton, both of us appearing over Zoom.
Thank you. Today was the date and the time that was set for a pretrial on a assault battery. How are we proceeding today, counsel?
Yes, Your Honor, if I may approach, we have a plea sheet filled out based on an agreement I had with defense counsel.
You may approach. Okay, I have a plea sheet. It says that the people are offering for the defendant to plead guilty to an added count 2 of disturbing the peace pursuant to MCL 750.170. That's a misdemeanor, maximum penalty 90 days in jail and or $500 in fines. The people are going to dismiss count 1 upon successful plea to the added count 2, and there's a Killebrew agreement of no upfront jail. Mr. Nagel,
That's
is that
accurate,
the
Your Honor.
offer that's communicate to your client?
That's accurate, Your Honor. Thank you.
Okay, Ms. Newton, if you can unmute your device, please.
Yes, ma'am.
Okay, did you hear the offer?
Yes, ma'am.
And you want to accept that?
Yes, ma'am.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, ma'am.
Thank you. You can put your hand down. Give me just a moment. So much going on. Okay. Ma'am, in order to accept the offer, you have following rights that you would need to give up. You have the right to remain silent at a trial and not have silence be used against you. You have the right to a presumption of innocence at trial. You have the right to have the prosecution prove your guilt at trial, and they do that by proving each element of the charge being brought against you. They have to prove each element beyond a reasonable doubt. You have the right to cross-examine or confront any of the witnesses that the prosecution intends to call against you. You have the right to call your own witnesses or present evidence at trial that you believe would further a defense to the charge being brought against you. Are you willing to give up each of those rights, including your right to a trial, in order to accept the offer today?
Yes, ma'am.
Okay. Anybody threatening you to get you to want to give up those rights today?
No, ma'am.
Any promises being made to you in exchange for you giving up the right?
No, ma'am.
Are you currently on probation or parole?
No, ma'am.
Understand that a guilty plea can result in the conviction that you may need to report to your employer?
Understand.
Okay. And you understand that a guilty plea can result in the conviction that may have impact on any travel or immigration status that you may be seeking?
Yes, ma'am. I understand.
Okay, and are you pleading guilty because you believe you're guilty?
No, ma'am.
Are you entering a guilty plea to the added count of disturbing the peace because you believe you're guilty?
Yes, ma'am.
Okay, are you saying yes because your attorney nodded yes?
No.
Okay, very good. Okay, as to the added count of disturbing the peace, how do you plead?
Guilty.
Have a factual basis, Mr. Nagel.
Thank you, Your Honor. Ms. Newton, I'm going to take you back to April 13th of this year at approximately 11 p.m. At that time, were you at the location of 1140 Cadwood Street in Lansing, Michigan?
Yes.
And Lansing, Michigan is in the county of Ingham?
Yes.
And at that time, did you have a dispute with Karen Nicole Lockwood?
Yes.
And did that disturbance create a disturbance to that was visible and audible to people in the public place outside of that residence?
Yes.
All right, I think that satisfies the factual basis, Your Honor.
questions from the prosecution?
No, ma'am.
No.
You're not the prosecution, sweetheart.
Oh, I'm sorry. I'm so sorry.
Andrea McCray appearing on behalf of the people, Your Honor, P number 83698. So if we're gonna do the factual basis to disturbing the peace, it has to be a disturbance in public. I'm not sure that based off these facts that we have that, he can always do the factual basis to the underlying charge.
Mr. Nagel?
That's fine, Your Honor. I'm trying to read the statute and make it apply. I can go further. So, all right, Ms. Newton, on that day, when Ms. Lockwood and you had a disagreement about who had access to the home at the previously stated location?
Mm-hmm.
And
Yes, sorry.
Yes.
Yes.
and you were trying to prevent her from entering that residence?
Yes.
And when she gained access to that residence, did you strike her?
Yes.
And that was because you believe she did not have access, she did not have permission to enter that premises?
Yes.
Sounds like it's given self-defense to me.
Yes, that certainly is self-defense. So I don't think that is gonna.
That factual basis would not be sufficient because that sounds like self-defense.
Well, did Ms. Lockwood in fact have permission? Did Ms. Lockwood in fact have access to the premises because she currently lived with you?
No. She did not live with me at that time.
Okay, the police is gonna fail at this point. We can reset this matter. You all can renegotiate or do what you need to do. But it does sound like she has a valid self-defense. This matter was gonna be reset or set for sentencing anyways, because with a victim, I need a victim to have their right to appear for a sentencing if a plea would have went through. So we can reset this matter. I can set it for a final pretrial if that's what you want and require the victim to appear. And that way, if she does enter a plea, the victim will be here. We can proceed to immediate sentencing at that time.
We can do that, Your Honor.
Okay.
Pretrial, July 10 at 8.
July 10th at 8. In person at the court.
And then jury trial, July 24th.
If this is gonna go to trial, it'll be July 24th at 8 a.m.
Both those times work, Your Honor.
Okay. Any additional matters for the record today?
Nothing further from the people. Thank you.
Nothing further from the defense, Your Honor. Thank you.
Thank you. Okay, let's see here. I have Kim Kwok on a motion. Mr. Kwok, do you have an attorney representing you?
No, I don't.
Okay, and then I have Gonzani on a motion. I think that's what this matter is. Did you all get the objection from the Attorney General on that one?
We did, yes.
I'll call the case. We're on the record in the matter of the people of the state of Michigan versus Travis Michael Benzani, file number 10-03158. Counsel appearance.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
Mr. Benzani, do you have an attorney representing you at all?
No, I do not.
Okay, today was the date and the time that was set for a motion to hear an application to set aside conviction. Mr. Benzani, you filed an application to set aside a conviction seeking to have a domestic violence date of conviction August 5th, 2010 set aside. We received an objection from the Attorney General's office. Did you get a copy of that, sir?
I do not believe I got an objection.
Okay. And the prosecutor from Ingham County did receive a copy of that.
Yes, Your Honor.
And are you joining in that objection?
Yes, Your Honor, we would join with what the Attorney General says, although the way I read it, it's not necessarily an objection to having this expungement. It's just he has a few things going on and he would have to pick between some.
Okay, so Mr. Bazzani, the objection reads, since you don't have it, I'll read it on the record for you, then we'll make sure you get a copy of that. It says, given the information currently in possession of the Attorney General, the review of your application and criminal history report shows that you may be eligible to have the conviction set aside under MCL 780.621. It says the application to set aside under MCR, which is the Michigan Court Rule 780.621, may only have a total of 2 assaultive crimes set aside in his or her lifetime, be they felonies or misdemeanors. In this particular case, sir, it says you are requesting to have 2 assaultive crimes set aside in the 55th District Court and 1 assaultive crime set aside in 54A District Court, while being eligible to have 2 assaultive convictions set aside under Michigan Compiled Law 780.621. Thus, even if otherwise eligible, for a set aside, it says you would have to choose which 2 assaultive crime convictions you wish to have set aside amongst those 3 cases, okay, sir? Because you filed a motion to set aside 2 in the 55th District, and then you have this one in 54A. You understand that?
Yes, I do.
So this is what I'm gonna do. I'm gonna reset this hearing. I'm gonna have our court send you a copy of this objection so that you can identify which 2 you want to proceed on, okay?
Thank you.
You'll receive a copy of your next court date in the mail, okay? As Sean said, please. Do you have any questions today?
No, ma'am.
Okay, you're all set, sir. Thank you. Okay. I've got this young man in waiting for a while. Make sure he's still there. Okay. And then somebody else was put out there because they. Someone else is here. Mr. Is it Raver Ren?
That's mine, Judge.
Yeah, I put him in the waiting room because he's not staying still and I don't want to get dizzy. He can't go on for a walk while he's in court. He's got to be ready to proceed in a court proceeding.
I'll give him a call and explain, Judge.
Thank you. Okay, Mr. Yeah, Mr. Goss here. Is that what's going on? On the record in the matter of the people of the state of Michigan versus Corey Goss Jr. Corey Goss Jr. I have 2 files. One is file number 20-01488, and the other one is 20-03656. Council appearance.
Good morning, Your Honor. Case Mark Aaron, appearing on behalf of the people.
Good morning, Your Honor. Attorney John Abbott representing Mr. Goss. He's standing to my right.
How are you, Mr. Goss? Today was the date that was set for a review on one of the files, but you were in bench warrant status on another file. And who was this gentleman that brought him to court?
Yeah, I'm his father.
Okay. Are you Mr. Corey Goss Sr.?
Yes.
Okay. Were you aware that he had a previous court date?
No, I wasn't.
Okay. So you did have a court date back on May 2nd. Did you already advise him of what happened on that court date? No.
Yes, I did.
Okay. Essentially, Mr. Goss Jr. was found incompetent to stand trial. It said not restorable yet. And so the court adopted that file. You can talk to his attorney about more detail as it relates to that. He needs to be placed, it says, in residential treatment, and we were waiting for a placement. Is that what it was?
It is, Your Honor, and we recently received this month a letter from the forensic, from the forensic examiners that there's nothing available currently.
Correct, and I think that they said about 6 to 8 week waiting period before anything becomes available. We have a few people waiting. For bed. And so to be clear, as it relates to file number 3656, the examiner did state that there was a possibility that he could be restored to competency within the time period, due to the fact that his legal guardian was misinformed about his last court date. I'll quash the bench warrant in that file. We're going to set these both for a review date. So that we can follow up on the placement for residential treatment. I had not signed the warrant for today yet, so we can.
Thank you, Your Honor.
They updated us, I would say about the 2nd, and they're saying that the beds are taking 6 to 8 weeks. Let's go 6 weeks. I'm sorry. No, not months, 6 to 8 months. They're taking 6 to 8 months to get a bed. I couldn't possibly be within the statutory period to restore competency. I'm not. What is that for? That was because he's the same waiting for bed. That's is that for hospital treatment? No, that's different. Yeah, that guy, I don't think that guy could be released. Okay, we'll set this out 6 weeks. July 10 at. Oh, you know what? This one is actually, there's who's KAJ? Who's the initials? There is a review on August 7th on the. That's the day we'll do it, August 7th at 9:30. And that will do both files for that date. Any additional matters for the record today?
Nothing further from the people.
Well, thank you, Your Honor.
We'll get Mr. Goss Senior a copy of those notices. Thank you. That's back. Why? Can you have them wait for the notice? Thank you. Ms. Newton, did you need something?
No, ma'am, my computer was having issues. I'm sorry.
Oh, you're fine. We reset your matter to a final pretrial, so you can call your attorney and you all will discuss how you're gonna proceed at that time, okay?
Okay, thank you.
You're welcome. Are we ready on Torres?
Yeah. Yeah. That was. No, I mean, for final crucial and jury trial, because there's no offer in my hand.
Are we ready on Mr. Graverin?
I believe so, Judge. I believe he's now in a stationary place.
Thank you. On the record in the matter of the people of the state of Michigan versus Nelson Graverin, I file number J006735 appears for the record.
Morning.
Sean McDermott on behalf of Mr. Graverin, who's appearing via video without objection.
Can you repeat your appearance, please?
Casey Markarian appearing on behalf of the people. Thank you.
Today was the date and the time that was set for hearing on a motion to set aside conviction. Looks like we did receive a response from the Office of the Attorney General. They do not have any objection. So long as this, the circumstances warrant setting aside the conviction. Any objection from the prosecutor's office?
No, Your Honor, we would join in the AG's.
Okay, and so Mr. Graverin is asking or seeking to have a conviction from 2001 for assault and battery set aside. Is that correct, Mr. McDermott?
That's correct, Judge.
You advise what your client's been doing since the time of that conviction.
Judge, for the last 5 years, he's been employed as a Uber driver. He's raised two 25-year-old daughters that he's still supporting. He's married, has had trouble seeking other employment other than temporary jobs, such as driving for Uber because of this conviction. Has no other convictions after this conviction. Crime free. He's a high school graduate from Cuba originally. So this obviously is hindering his ability to provide for both himself and his family, and as well as possibly obtain citizenship. So a big factor for him, and the ability to get his green card and citizenship. So. Is that all correct, Mr. Graverin?
He's muted.
Mr. Graverin, you need to touch your phone, hit unmute. Mr. Graverin, you need to unmute your phone.
All right.
Mr. Graverin, did you hear what I said? Was everything true and accurate?
Yes.
Okay, anything?
Yes. I'm here, yes.
Okay, anything you would like to add to let the judge know what's been going on with you since this conviction?
Yeah, this happened a long time ago, and I get out of trouble. I never get trouble again, and I'm stay working and with family, with my granddaughter, my grandson, and
and I working for Uber every day. So I'm doing right now. I'm doing good right now. You know, I never get sober again.
Thank you, Mr. Graver.
So
Thank you. I do have a copy, sir, of your criminal history. I just want to clarify because the thing has been stated 3 times that you never got in trouble again. It looks like you did get in trouble twice since then, but they were not assaultive crimes. You do have 2 other convictions or 3 other convictions on your record. You do recognize that, sir?
yeah, I recognize that, but it's a long time ago. It's like 17 years ago.
I absolutely recognize that these are old convictions, but you said you never got in trouble again since this 2001 conviction. You did have a conviction in 2004, and you had another conviction in April of 2001. So I wanted to make sure you were not oblivious.
Oh,
to
yeah,
that.
yeah, I recognize. Yes, yes.
Okay, very good.
And
But
I'm
as it
sorry.
relates to this,
I misspoke,
I'm
Judge.
sorry.
I apologize.
Okay, those convictions were not assaultive in nature. Nonetheless, I've reviewed in your request and application seems to comport with the statute. It does seem that the circumstances in your behavior since 2004 at least would warrant granting this application as it is consistent with the public welfare. So I will grant your request and set aside this conviction. Okay, sir?
Okay.
That order will be signed and dated for today. Do you have any questions at this time?
No, thank you.
Any additional matters for the record, counsel?
No, Judge, thank you. Congratulations, Mr. Graver.
Thank you. Thank you. Appreciate it.
Trust from the people. Thank you.
Thank you. Good luck to you, sir.
Yep.
Thank
you
you.
can log
Thank
off.
you. Have a great day.
Same to you. Okay, who do we have next? You met with Mr. Torres, is that correct?
Yes, I did, Your Honor.
Okay, we're on the record in the matter of the people of the state of Michigan versus Matthew Richard Torres, file number 23-00818, counsel appearance.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Matthew Torres, who is appearing separately by Zoom.
Today was the date that was set for a plea. How are we proceeding today?
Your Honor, at this time, there is no offer for Mr. Torres to accept. At this point, I wouldn't have him plead guilty. I just set it for a found for a challenge jury trial.
Let's see, we'll set it for a trial. It will be July 31st. July 31st at 8 a.m. Any additional matters for the record today?
Nothing further from the people. Thank you.
Nothing for defense. Thank you, Your Honor.
Thank you, Mr. Torres. Your trial will be July 31st at 8 o'clock in the morning in person at the court, okay?
Yes,
Okay, you're all set.
thanks.
You're welcome. Who's in the jail? Not Tanner, I recognize Tanner. Who's the other individual?
Zachariah Richardson.
Say it again?
Zachariah Richardson.
Oh, Zachariah Richardson.
That'd be me, Your Honor. I need a breakout room with him.
Okay, Mr. Richardson, your attorney needs to speak with you, so give me just a moment.
Yes, ma'am.
I see Bradley. Bradley, what's your last name?
Gary, Gerry.
Okay. Who's representing Bradley Gary?
I am.
Do you need to speak to him?
No, we're prepared to proceed.
Okay, we're on the record in the matters of the people of the state of Michigan versus Bradley Allen Gary. The file numbers are 23-01072 and 73. Counsel appearance.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
Assistant Public Defender John Lee appearing on behalf of Bradley Gary.
Thank you. Today was the date that was set for pretrials on both files for dog at large. How are we proceeding?
Yes, Your Honor, we did receive photographic evidence from the defense of the problem of the fence being fixed. It seemed like this was a one-time issue. The people would move to dismiss as such.
Okay, both cases will be dismissed. You're all set, Mr. Gary.
Thank you.
You're welcome. Ms. Donnelly, did you have another matter before you want to talk to your client?
I do have Rodrigo Quintana here, Your Honor.
Excuse me, you said I'm all good to go, right?
Yep, you're all set to go. Your cases are dismissed.
All right, thank you.
Okay, this is set for a hearing on a PA 53 violation, and then it looks like there's a new PA 53 violation.
Yes, Your Honor.
Okay, that you need to be arraigned on.
Yes.
So I'm gonna let you go speak to your other client. I'm gonna handle Mr. Kwok, who's been sitting here for a while, and then we'll handle Quintana. Okay, we're on the record in the matter of the people of the state of Michigan versus Kim Young Kwok. File number is 18-00124 SM. Council appearance.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
Oh, Ms. Donnelly, you're already in room one.
Yeah,
That's
I
why.
see.
Gotcha. Richardson.
I am here. Can you hear me?
I can hear you, sir. So Mr. Kwok, today's the date and the time that was set for a hearing for a motion to set aside a conviction. You are seeking to have set aside a conviction of disorderly person from February 2018. That's correct?
Yes.
Okay, can you please advise what you've been doing since the time of your conviction in 2018?
Yes, I have a seasonal job in the spring and summer with Pearson Education, and I volunteer with several different local organizations.
Okay. What are some of those organizations?
Greater Lansing Food Bank, Michigan Institute of Contemporary Arts, Downtown Lansing Inc., East Lansing Art Festival, Capital City Film Festival, and Downtown Lansing Inc.
Okay, sounds good.
And Volunteers of America.
Okay, very good. So it sounds like you've been staying out of trouble, correct?
Yes.
And you've been using your energy for more positive things and for more engagement in your community.
Yes.
Very good.
However, my Pearson job is seasonal, and I've been having trouble trying to find a full-time year-round job because of the conviction.
Okay, sounds good. I did see here that we did receive a response from the Office of the Attorney General. There was no objection. I believe that there would be no objection from the Ingham County prosecutor, but I'll confirm that.
Andrea McCray appearing on behalf of the people. That's correct, Your Honor. No objection.
Okay, very good. And so in review of your prior criminal history, sir, I don't see where you've had any engagement with the criminal justice system since the time of this incident, which is positive. And I believe based on a review of that, plus what you've stated here in the court as to what you've been doing since the time, I think that granting your request to set aside this conviction would be consistent with the public welfare, as I find that the circumstances and your behavior are appropriate at this time. So I'm going to grant your request to set aside this conviction. Order will be dated and signed for today, okay, sir?
Yes, thank you, Judge Simmons.
No problem. Do you have any questions for the court?
No.
Okay, any additional?
Oh, yes, I do.
Yes.
When can I expect this to be off of my iChat?
I believe it takes at least about 60 days, but you can't quote me on that. I know that they got to get an order and then it goes over to the state police.
Okay.
But you should follow up with the state police and find out how long it's taking them to process that, okay?
Okay.
Any additional questions?
No.
Okay, you're all set. Thank you.
Welcome.
Let's see. That was all set. Did we do Pisano or did I make that up? No. Did we see shots in Pisano? No. That's unfortunate.
Nick said he's like a doctor.
Plastic. We don't need, it could be any city attorney.
That's what I said.
No, we just need a city attorney. It could be anyone. Because the guy was ready today. And so we need somebody here today. Did you contact the city attorney's office or you contacted Staples? Staples. No, we need to contact the city attorney's office. That's the problem. Do you have a Booth's email? Put a Booth on there and Smirka. Okay. Okay. That's the one I'm waiting for right there. That's the Chia. And he's in custody. Pisano failed to appear. Who else do we have?
We have Montana, but I think Miss Donnelly's outside.
Is that the only other person in the courtroom?
I think so.
Okay. Okay, and then Mr. Lee's matter. Mr. Lee, we're not having a hearing, are we?
Mr. Tanner?
Yes.
No.
Oh. Mr. Tanner, can you wave your hand? You need to make some motion so that the light comes on. Thank you.
Yeah.
I don't know why it's not letting me. Oh, there it goes. On the record, in the matter of the people of the state of Michigan versus Zachariah Richardson. File number is 23-00855, council appearance.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of defendant Zachariah Richardson, who is appearing separately from the Ingham County Jail.
Today's the date and the time that's set for a pre-trial on a domestic violence. How are we proceeding?
Your Honor, at this time, there is not an offer. They don't have any objections to a Killebrew to no upfront jail. At this time, we'd be requesting it be set for final pre-trial and jury trial.
can do final pretrial July 24th at 8 a.m. July 24th at 8 a.m. Jury trial July 31st. God bless you. Final pretrial July 24th, 8 o'clock in the morning in person at the court. Jury trial July 31st, 8 o'clock in the morning in person at the court. Do you have any questions for the court at this time?
You said July 31st?
That's the jury trial date. Your final pretrial is July 24th.
Okay.
Do you have a question about that?
Can we do it sooner? Like, I was trying to get out before my son's birthday. His birthday, July 27th.
Well, we don't get to just make up dates. We definitely put that at the earliest possible date, but your bond was 1,010%. So you're not being held on unreasonable bond. You're saying you can't post $100 bond?
Oh, I can post $100 bond. I'm so sorry. I did not know it was just $100.
Yeah, your attorney says you have some other matters, so you're not being held on this. On a high bond. This one's 1,010%.
Right, and then I got a 10,000 cash of surety for my other case.
Yeah, that's not this one. So moving the date up won't help you. Moving the date on this one won't help you because that's not this case.
Okay. I'm sorry.
You're fine. I just want to make sure you're clear on that. Who was the other file before? It's not here.
It was you.
Oh, okay. Sounds good. That's a felony then, correct?
Yes,
Got it.
separate from the exam.
Okay, sounds like you have a matter set for preliminary exam, okay? On the other file. You understand, sir?
Yes, ma'am.
Okay. Do you have any questions?
No, ma'am.
Any additional matters for the record, counsel?
Nothing further from the people. Thank you.
He's here, so he just has to go get him. Isaiah is here, he's in the hallway. Did you call, can you call the hallway for Sino? Sounds like he's here. And, okay. Oh, Amanda can log in.
She can,
Very
she said
good.
whenever.
Thank you. And then, Mr. Richardson, unless you have any questions, you're all set.
All right, thank you.
Thank you. Okay, that's Mr. Pisano right there. Mr. Pisano, do you have an attorney? What's happening?
No.
Okay. We'll let you talk to the prosecutor then.
We're ready on Fasano.
Thank you. We're on the record in the matter of the people of the state of Michigan versus Jackson Fasano, file numbers 23-00914915. Appearance for the record.
Andrea McCray appearing on behalf of the people.
And then Mr. Fasano was present in the courtroom without an attorney, correct?
Correct.
Today was the date and the time that was set for a pre-trial. I have one file with an unlicensed dog, the other with a dog at large. How we proceed?
Judge, at this point in time, the people have received proof of the vaccination license and the fence. So we're moving to dismiss both matters.
Okay, motion to dismiss is granted. Both files are dismissed. You're all set, sir.
Thank you.
Okay.
They're going to go to them.
Thank you, Mrs. Oakwood. We have, for some reason, Mr. Escochia was written here today, so they're gonna bring him up.
Okay, no problem. Is he represented here?
Correct. Okay. You have Quintana. On the record in the matter of the people of the state of Michigan versus Rodrigo Ponce Quintana, file number 23-01122. Council appearance.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of defendant Rodrigo Quintana, who is present and standing to my right.
Thank you. Today was the date and time that was set for a pre-trial. Okay, looks like we set this for a hearing on the PA 53 violation. The last hearing, I remanded him for a GPS tether. Did you get that, sir? Okay, it looks like we have a new PA 53 violation. Ms. Donnelly, did you see this report in the text messages?
I have, Your Honor.
Okay. Okay, so I have a new PA 53 violation. The allegation, sir, is that you violated the terms and conditions of your no contact order by making contact directly with the alleged victim on or about May 15th, 2023 via text messages. There's an attachment of text messages to the police report, which was submitted by the Shiawassee County Sheriff's Department. You have the right to have a contested hearing on that. You have the right to be represented by counsel. If you're found to be in violation, at this point, you probably be revoked if you're found to be in violation. I'm just gonna be frank. Do you understand that? Okay. And how does he want to plead?
He's gonna plead not guilty at this time, Your Honor.
Okay, we have a victim here today.
Yes, Your Honor, we do.
Okay, we're proceeding to our PHP violation hearing today.
Your Honor, there are, now that there are, all the violations are with the same complaining witness. I would like to run all of them together. Might as well not have two. I know that she's here, but if we could run all of these together, because this is, we would be requesting a contested hearing. I know that she's here and ready to go. I would just would like a brief adjournment so that I can be prepared for all of them.
Sounds good. I'm gonna revoke bond pending the hearing. Be remanded into custody. So we'll get your hearing date. June 12th at 10. June 12th at 10 a.m. for hearing. What's going on with are we proceeding to trial on the underlying matter?
No, on the underlying, well, Your Honor, on the underlying matter, we have never set it for final pretrial. And I know that there isn't currently an offer on that one, so.
If we're continuing to trial, we can do that. I'm not gonna set it for a special final pretrial when I've already got the victim here today, and the victim's gonna have to come back on June 12th. So
Yeah.
we can do a final pretrial June 12th.
I agree, Your Honor, because I also would like the opportunity for him if he wants to accept an offer or plea at that.
Okay. We can move on to the 8 a.m. Okay, June 12th at 8 a.m. for the final pretrial. And then jury trial.
Pretrial will drop July 31st.
July 31st at 8 a.m. We'll get you a copy of your notice to appear. If you need a printout for your victim or well, or you're just gonna subpoena.
We'll just subpoena. Thank you.
Sounds good. Any additional matters for the record?
Nothing further from the people. Thank you.
Nothing for defense. Thank you, Your Honor.
Oh, I forgot to put a little. You're all set for today.
Yeah. Yeah.
What else do we have? We're waiting for them to bring somebody upstairs.
Yes, for sure. They said that the impounded.
Since we have a, but if you want to help me deal with that, I would be happy.
What about phones? Do you know what's going on with phones? This person needs to be reset and rewritten.
Yeah. Yeah. For mental health court. Okay. He actually got approved. And he's his fundraising.
You sent him for a
Yeah.
Okay. I think you don't have to. Here's the thing, he's got advanced.
Sure.
Oh, God. Yeah, he's in an AMC now.
Wait, so Javon Shaw was in adult foster care and we need to do what?
I need to work out the global resolution on whether he's gonna go into mental health court or not, and then if I need to get him here, his AFC is asking me to, need to
Get a
email you
link.
guys, yeah, get a link for your Zoom so I can email you.
Okay, future date.
So that, because
Both of those.
she just got up, so now.